All right, good morning. We're here on the minor guardianship docket for March 14th. I'm Commissioner Dave Nelson. Is Crystal Garcia or?
Yes, yeah.
Let's see. Kaufman is here. And I see Emily Kaufman.
Your Honor, Vashti Langford here, court visitor.
All right, thank you. What I indicated needed to happen is apparently the biological parents have lost their parental rights. Then there was an adoptive mother, and with the adopted mother, there was a appointment of a minor guardian, and now the minor guardian wants to switch and replace Crystal Garcia wants to be replaced with Emily Kaufman. What I indicated last time was that the adopted mother needed to be served with that request. I haven't seen a proof of service. Ms. Langford, were you able to talk to the parties about that?
So, yeah, sorry, my camera won't turn on. So I apologize, first of all. I did talk to all parties. I personally went to the residence a couple times and no one responded. I talked to Emily. She stated that she tried to get her served a couple times, and I believe she was trying again yesterday, I believe. I don't remember off the top of my head. She is on the call on here as well, so she could respond to that. But I know I personally tried to go to the residence that we had on file. No one would answer. I went 3 separate times. No one would answer the door for me. And I know Emily was having a similar situation as well.
Okay.
So I did have somebody go yesterday to try to serve her. She did answer the door, but when they went to try to hand her the paperwork, she slammed the door in their face. So, I mean, I tried my best.
We do know where she lives anyway. Is that right?
Yeah.
For now. I apparently she won't be there soon, much longer.
Well, we still need to get service, and it sounds like at this point, I guess it would be Ms. Garcia who's bringing this petition. But one of the parties should bring a motion to serve by mail, indicate in the motion the attempts to serve that have been made, and the court should sign off on that so that you can just serve it regular mail and certified. And if I put this over 2 weeks and you've done that, then we should be able to go forward and do the switch at that time. And Ms. Langford can be a resource for you as you file that motion. All right.
Okay.
Okay. So let me look at a calendar here. That would put us over to March 28th. When you send it to the adoptive mother by mail, then you should file a declaration with the court indicating what date you sent it to her. And so the court has that information. Okay.
Okay.
Ms. Langford, I had a question for you. Are you still taking appointments in Chapter 11 cases?
I am not. I requested a family leave. If it's something you think I can handle, I can take it, but.
All right. We knew you didn't want to take appointments in Chapter 26. And if you don't want to in Chapter 11, then
I did email and about
next. Let's go to Caitlin
right,
Wallace.
Yes, Your Honor.
I just saw a note, I think, from you.
Yes, Your Honor. Every party agrees except for Mr. Wallace to the final orders. If I can be put in a separate room with him just real quick. I don't know what line he doesn't agree to. And maybe if we have to litigate that specific line, that would be fine, but it seems like everybody else is on board with everything. I just want to know what his issue is.
Okay. Mr. Wallace, are you there? Do you want to unmute yourself?
Yeah, I'm here, Your Honor.
All right. So on Zoom, I don't know if you've done this before. I can put you in what's called a breakout room. So I'm going to put you and Ms. Winkles in a breakout room so you can talk to her directly without talking to everybody else. And
Thank you, Your Honor.
and hopefully you can discuss your issues. I'm not suggesting by doing this that you need to agree to anything, but I am allowing the two of you to talk. Okay.
Yes, Your Honor. I tried calling her a couple times this week. We were just unable to connect, so.
Yeah, and I've been ill, so I'm at home. It makes it very difficult.
Okay. Well, in this breakout room, you have plenty of time to talk. Okay. Anybody
Thank you.
here on the Guardianship and Maisie Alexander? All right. Well, Donna Alexander's in the waiting room. Let me get her in. Ms. Alexander, can you hear me? Ms. Alexander?
Can you hear me, Your Honor?
There we go. Okay. I got an email from Tina Day, the guardian ad litem, indicating that she needed a few more weeks to complete her report. And so what I'm suggesting is that we put this case over 3 or 4 weeks, and I can extend the immediate emergency guardianship order during that time. Will that work with you, Ms. Alexander?
Yes.
Okay. Just to give us enough time, let's put it over about 4 weeks. So that will be April 11th, and I'll file the extension of that order later today. Okay.
Okay, and
Right.
that is still is a 10:30 time?
Yes, that will be 10:30 on Tuesday, April 11th.
Okay, thank you.
I am here
Thank
on
you.
that matter.
All right. Good morning, Ms. Overby. Ms. Smith.
Good morning, Your Honor. I received a call from Tim South yesterday indicating that he had a rescheduled medical appointment, so his appearance isn't here. It's my understanding that this hearing was for orders that he was supposed to present.
We're here for a review, and I got the same note just now that he apparently has surgery today. Anybody else here on the guardianship help?
I am, Shauna. I'm
Oh,
here.
okay. Good. Good morning.
Good morning.
Let me find out a couple things and we'll decide what we do. Were you able to have any of the video visits?
I had one and I missed one.
Okay. Any in-person visits, supervised visits?
No, because I wasn't aware that I could have those.
Okay. Ms. Smith, were you able to speak to the parties or look at this at all?
Yeah, so just as a reminder, I have a GAL investigation pending on the parenting plan, the pro se parenting plan. So I have previously started my GAL investigation. So in conjunction with that, I'm completing the court visitor report. I should be able to have the court visitor report because it's so limited. I should be able to have that filed next week. But I kind of have 2 competing investigations.
Okay. Mr. South has asked that this be put over as a result of his surgery. It looks like we need a little more time for the court visitor report. If I put this over 2 weeks, will that work with you, Ms. Ray?
Yeah.
So that would be to the 28th. Okay, I'll continue the immediate emergency order. My expectation is hopefully on the 28th that if the parties do not agree, that we have a hearing on the emergency minor guardianship order on that date. Okay, so if you want to plan on that. Okay.
Is there anything that needs filed for that hearing?
I think Ms. Smith's report is probably what I'm going to need. And then what we usually do is place the various parties under oath, and they can testify as to why the emergency guardianship should be entered and why it shouldn't. And then based on the statute, I'll make a decision. Okay.
Thank you.
Okay. All right. We'll see you back here on the 28th.
Thank you.
Your
Thank
Honor.
you.
I don't know how to do.
All right. The next case will be guardianship of Hazel.
I'm here, Your Honor. Can you hear me?
Yeah. Is this Miss Kuwanoni?
It is.
Did I say that right?
Kuanoni.
Kuwanoni. Okay. Thank you. So this case has just started, and what we typically do, Ms. Kuwanoni, is appoint a court visitor to work with you. That's done at county expense. And one of the things that we'll have to look at is getting the mother and the father served. I understand is the father still in prison?
He is.
Okay. There's a process to do that, and to serve him in prison. The court visitor can work with you on that. So we do this on a rotating basis. I'm going to appoint Sherry Farr. The last name is Farr, to be the court visitor. She should be contacting you probably by the end of this week to discuss the issues in this case.
Okay.
All right. And looks like Hazel, she's 9 months old. She's staying with you right now. Is that right?
Yeah, she's been with my family here in my home since she was a week out of the hospital.
Okay. All right. Well, I think what I need to do is put this over a month to give Sherry Farr a chance to do some interviews and give you a chance to get the parents served. And then we'll come back in a month and look at the emergency. Well, actually, you're asking for a full guardianship order. So we'll take a look at whether there's any objection or whether that can be entered at that time or soon after that. Okay.
Okay. So until then, am I emergency guardian then?
Well, you haven't filed for an emergency guardianship. You filed for a full guardianship, is what I have on the petition.
Okay.
If you want to, and maybe it might be a good idea, you could find the emergency minor guardianship petition, file that along with a motion for order to show cause why you should not be appointed right away. And the court will probably appoint you the emergency minor guardianship right away.
Okay. I was supposed to be, I'm sorry.
Go ahead.
I was supposed to be co-guardian with my daughter, who is her emergency guardian now.
Okay.
And then she missed her court date. And Tina said that I needed to go right in and apply for full guardianship. So I'm kind of at loss here. I don't know.
I think what I would recommend is that you do get the paperwork for the emergency minor guardianship.
Mm-hmm.
And go ahead and file that. And again, that will come with a motion for order to show cause. That has to be heard fairly soon. So you might actually be in court before a month from now on that petition. But that would give you the authority to continue to care for Hazel.
Okay.
Okay. I'm going to put this matter over to April 11th. And if you show up on a minor guardianship on the emergency petition before that, and I don't remember, remind me that we have this other case set on April 11th.
Okay.
So I can set them beginning on the same date going forward.
Okay. All right. Thank you so much. And it's Farr.
Farr, Sherry
Okay.
Farr.
Sherry Farr. Okay, thank you very much.
And again, you'll hear from her shortly. Okay.
Okay, thank you. Have a nice day.
Part of the issue here is I think I've appointed Mr. South for one or more of the parties in this case.
That's correct, for the mother. And it's my understanding Sherry Farr is the court investigator. So it looks like we're missing a few people. I haven't been able to contact, I've been appointed to the father, so I was wondering if this matter could be set over. It probably needs to be set over for Mr. South, and I'm not sure why Miss Farr is not here.
Yeah, I don't see her in the waiting room either.
And
does anybody on this case have an objection to this being put over 2 weeks? Because Mr. South is in surgery and Ms. Farr is not here.
We don't have an objection, Your Honor, but we're asking also for, you needed an attorney for the children, is that correct?
And we haven't heard anything from the court visitor that you appointed in the beginning as well. And I was
Okay.
kind of wondering about that.
Okay, thanks for letting me know that. Just one moment on the.
I believe, yeah, I'm not sure how, I thought Jackson was.
I've got Jackson at 12 years old.
Okay. I thought 11, so.
A child has to be at least 12 years old before we appoint an attorney. If you're requesting that an attorney be appointed for Jackson, typically Aaron Winkles, who you saw earlier, represents children in these matters. So I would have to ask her if she'd be willing to take that on.
Okay.
If she is, then I can go ahead and appoint her and do that before 2 weeks from now. It probably means we're not going to be able to have a hearing on the emergency minor guardianship 2 weeks from now because we have a new attorney in the case.
Right. I just feel like he needs one to represent him at this point, if the parents are also getting an attorney.
Okay. All right. I'll check with Ms. Winkles on that. So in Baldwin, then we'll need to put it over to March 28th at 10:30. And I'll check with Ms. Winkles later today to see if she'll accept that representation. Okay.
Okay. And if she doesn't, will I hear from somebody or wait until the 28th and have it be pushed over again?
If she doesn't, I'm not sure what I'm going to do. The three attorneys that we've been working with on these cases are Tim South, Mr. Anagnostou, and Aaron Winkles. So all three of them are involved already. So I'm not sure who I'm going to select after that.
Okay.
Okay.
But I will hear from somebody.
I will work with my judicial assistant to find somebody.
Okay. And then the court visitor, are they supposed to be calling us? Or are we going to be appointed a new one or?
She's supposed to be contacting you. So I'll probably just send her a quick email and ask her if she has enough information to get a hold of you.
Okay. All right. Thank you.
Okay.
And can I ask a question of the petitioners, Your Honor?
Yes, go ahead.
In their pleadings, they indicated an address for Lacey and Vance. I was just wondering if they know if that's still a current address or not.
Yeah, that's her current address. I think somebody from your office or Vance's office had called asking for a number for Vance to try to get into contact with him. And I provided the last known number that I had for him.
Okay.
So as far as I know, that's where they've been staying. Vance might be with his biological mother as well. I don't know her address.
She actually lives in Castle Rock, and that is where Vance is staying. I have a number for Vance if you'd like it.
Oh, that would, I would like that. Should I get that now, Your Honor, or call them later? And
Would you mind calling Mr. Anagnostou's office?
Sure.
I can give I can give you that number. I don't like private phone numbers going out on YouTube.
Right.
So, but office numbers, I don't have a problem with. So call Mr. Anagnostou and provide that information. Okay.
Will do. He
That'd
just
be great.
contacted me about a week ago via text with a new number, so that's all the information I have.
All right. Any other questions on the Baldwin matter?
Nope.
Okay. And we'll see you back here then on March 28th. Yes, just okay. Can I just take care of one thing first, Ms. Vashti or Ms. Langford? Brianna Alexander. Ms. Alexander, are you there? All right, I'm going to go to Ms. Langford and I'll come back to Ms. Alexander. Ms. Langford, go ahead.
Yeah, I was just looking last week. I didn't have a new order for as appointed for GAL. I know we verbally talked about it in the emergency approval, but I never got an order for it.
On the Kaufman case?
On the Wallace case.
Oh, on the Wallace case. Okay.
Yeah.
Were we going to change that to county pay?
I was court visitor and we switched it from court visitor to guardian lighten for the
Okay.
yeah.
So I'm switching it to guardian ad litem. All right.
Yes. Thank you.
I'm sorry if I didn't get that done, but I've made a note, so I'll try and finish that today. Okay. All right. Brianna Alexander sent me a note saying she can hear me. So we've called this case already. And what I want you to know is the court visitor, Tina Day, needs additional time. So we put this case out to April 11th at 10:30.
Commissioner Nelson, my apologies. I think we're going to need to set this over 1 week. We're pretty darn close. I'd ask that Mr. Wallace, I'm going to give him a call right now. And I think we're really close, but I would hate to take more of the court's time.
Okay. I have another hour for this docket. If you think you can do it today.
I think I can. If you want to put us back into that room, we'll finish off. And then if everybody else can check their email within the next 15 minutes to give me a yay or a nay on that order, that would be very appreciated.
Okay, I think it makes more sense if we can get this done today. I'd like to.
Perfect. Perfect.
So Mr. Wallace, I'm going to put you back in the breakout room with Ms. Winkles. And I'll give you 5 minutes. For everybody else, we're going to go off the record. So just stay on Zoom, and then about 5 minutes from now, do you think 5 will do it, or do you need 10?
Probably maybe 10 or 15, because I got to read through this whole thing real quick.
All right, let's go 10 minutes, and then we'll check in.
Thank you.
So it's 11:05. I'll check in a little after 11:15.
Sounds good. Thank you, Your Honor. Commissioner Nelson? The father has requested before he signs anything, speaking to my child with me in the room concerning in-person visitation when that eventually happens. If there is a way Your Honor can put me, and my client has agreed, as long as Your Honor agrees, because there is a restraining order, to have Mr. Wallace, me, and the child in the room. If Miss Langford would like to be there as well as the GAL, that might be appropriate.
Caitlin just dropped off the Zoom call.
Oh.
So if you could ask her to get back on, I'm happy to do that. Is she with you there?
Yeah, I have her. She can use mine.
Okay. Let me ask her first. Caitlin, are you okay being in the same breakout room with your father?
Yeah, that's fine.
Okay. Miss Langford, do you want to participate in that?
If Caitlin wants me there, I can be there for her.
Okay.
Yeah,
I think,
that's fine.
okay. So I'm going to put Ms. Winkles, Mr. Ross, Mr. Wallace, Ms. Langford in the same room. Just hang on. And it looks like they're gone. So for the rest of us, we will go off the record again for a little bit. Ms. Wallace, your camera is open.
If the child approves it,
I'm going to get rid of her is what I'm going to do.
requested, and I'm gonna send them to everybody again. I'm hoping that that will be where we're at, if we can have another 5 minutes.
Okay.
Okay,
Ms. Winkles,
yes.
the visitation thing.
Mhm.
So I'll be making that long trip. I won't even know if I'll be able to see her or not. Is that what I'm hearing from?
Well,
Ms.
what
Ross?
do we do if the guardian can't get that day off work is the question.
Let me, I can put you back in the breakout room.
Okay,
Okay, just hang on.
okay, I am gonna send the order around real quick, Your Honor, to everybody. And everybody signs it, then we will, everybody knows it's coming. I'm gonna send it around real quick. And hopefully we'll have this in just a couple of minutes. If that works for you.
You want me to stay on the record?
Yes, if Your Honor can't, well, we can go off the record for 5 minutes. I'm sure it'll take about that long. And then I can email it. Once I have everybody's signature, I can email it to Your Honor.
All right, we'll go off the record. When you come back on, then we'll
Mr.
go back on
Wallace,
the
have
record.
you signed that? Sounds good, thank you. It doesn't go through the chain unless you sign it. So you sign it, then the next person, and then we get the final order. So if it's just sitting with you, it'll never go through.
I'm reading it. I'll get to it as soon as possible. Okay. I'm almost done with it.
Okay, thank you.
Thank you.
All right, we're back on the record in the unlawful, the minor guardianship.
Yeah,
docket.
Your Honor, I am still waiting for
Just checking
Mr.
in.
Wallace to sign off, and nobody else has seen it yet.
I don't know, is there anything more for the court to do if you're just circulating the order?
No, at this time, I think we don't have an agreement. I'll just set a trial.
Okay. And that would be on the full guardianship if you don't have an agreement.
It would be, Your Honor.
So you'd have to put it on the universal trust setting calendar.
Your Honor, I'm signing it right now. I'm just trying to get the signature thing to work. If you can give me 1 minute.
All right,
So-
thank you, Mr. Wallace.
In that case, if everybody can come on, since everybody has a copy. Oh, actually, Your Honor, can you give me 2 more minutes, because the CR 26I, if you do it on the record, if everybody has the same document, it should suffice. I can make sure everybody has a copy right now, and we can all come on the record and agree.
And that was what I was wondering, if you do want to put a settlement on the record.
I will send it right now to everybody. Mr. Wallace has signed it. It's called Order Appointed Guardian V3. If everybody can look real quick so we can come on the record and agree to the CR2A agreement. So, Your Honor, just so you know, we have Mr. Wallace's signature on it. We now have Miss Langford, the jail, signature on it. I believe I'm waiting on, we now have the mother's signature. And so we're just waiting for one of the guardians, because I think just one of them will suffice, and then we will have an agreement. Oh, and the minor child, obviously. Caitlin, Jared, and Kelly, do we have your agreement on that order appointing guardian version 3 that was sent?
Yes, I just signed it.
Okay, so we now have one of the guardians. We're just waiting for the child to sign, and then I will get the order over to the court.
I just sent it over.
It might go to Mr. Ross first. But if I have Caitlin's approval over on the record, that would be good enough.
I approve.
Okay, Your Honor, I'd like to enter the settlement agreement. The document is called Order Appointing Guardian version 3. Everybody has now signed except for Mr. Ross, who is a co-guardian, so Ms. Ross's signature will suffice. My client's indicated that she'll sign as well. I can sign in her stead as her attorney. So I'd like to enter that settlement agreement on the record.
Do you want to state what that agreement is?
Yes, the agreement is the order appointing the guardian. It's minor guardianship findings and order. It appoints the guardian as of today. It appoints both Kelly Ross and Jared Ross as co-guardians. The guardianship is a full guardianship. Both of them will need to do training within the next 60 days. The jurisdiction, this court has jurisdiction as the other state has declined. The notices have been given. The basis for the guardianship is agreement and need, as indicated in the document. With child support and healthcare insurance, the parties have agreed to reserve that pending motion if the guardian wants to bring that action, the child does not need to be present for that. The court has, the parties have agreed that taxes 2022 will go to father, 2023 and onward will go to the guardians. The guardians have full authority for the child's upbringing. However, the parents can have access to the school, educational, and healthcare records. The parties have agreed that visitation in person will be based on the child's consent. However, they have agreed already to a July 4th visit in Oregon for 2 to 4 hours with the father. The child will be transported by the guardian or another designated individual. When it comes to non-in-person visitation, both parents will be limited to certain hours when the child is in school and certain hours when the child is not in school, such as the summer, and that they can just do essentially video visits, email, things of that nature. If the child decides not to answer, that's kind of up to the child. The guardian ad litem will provide her fees to the court. I will be discharged, as will the GAL. My fees are within that order, so we can strike my motion for fees. Additionally, the father will package up the child's belongings and give them to the mother by no later than April 9th. The mother can bring them to Longview. Any other restraining order that's not in this will be terminated. And as I said, the issue of child support has been reserved. And that's the full agreement of the parties. The guardians will need to do an acceptance of guardianship or acceptance of appointment and get letters. And other than that, this case is done.
All right, thank you. If you want to submit that order to my attention, then I'll sign off on it when I receive it.
I will do. I'll submit that today, Your Honor.
I want to thank everyone, starting with Caitlin Winkles, the Rosses, and Mr. Wallace, Aaron Riley, and Ms. Langford for your good work in this case. This was a difficult case from the beginning. There were a number of issues, and it sounds like this is a reasonable settlement, given the concerns and issues that were raised. So thank you very much for that. I'll give an opportunity if anybody else wants to make a comment before we go, they can. Ms. Riley?
Yes, I would. Meeting the father, I would like to have it on a Sunday at Planet Fitness on Brixmore in Modesto, because I'm in town in Modesto. If he could just message me between now and April 9th, on any given Sunday, I'll be happy to meet him to get Caitlin's belongings.
Yes,
that's
Mr.
why we said April 9th, because that's why I said April 9th, because she is in town on Sundays. If she could just text me when she gets in town. I'm in town all the time, so when she gets there, text me and I'll bring it back to her.
Okay.
Okay.
Oh, when you say in town, do you mean Modesto or somewhere in California or here?
No, I live in Modesto.
Yeah, Modesto. Unless she wants to meet in San Diego, then no, I'm kidding.
Where's the meeting going to take place?
Planet Fitness. If he could bring me her belongings there, I can load everything up in the trailer.
All right, thank you. Okay. All right. All right, the next matter is Lorenzo Garcia and Serena Totten. Ms. Hyde is here.
Morning.
I see Mr. Garcia, Ms. Totten. Mr. Garcia just left. We're here for a review of the current arrangement that I indicated last time. I think it was 5 days in Vancouver with Ms. Totten and then the weekends with Mr. Garcia. I guess the question is, are you still going by that, or have things changed, and are we looking at a different kind of parenting plan? So Mr. Garcia, why don't you bring me up to date?
So things have changed. Even though I wasn't able to get into couples counseling because I was having issues with my insurance and where they accepted it and how busy they are. I'm in the process of renewing my insurance so that I can get into this couples counseling, but they're booked out still for a little bit for the ones that accept my insurance. Me and Serena have gotten a place together and now we reside together. She's still engaging with her therapy, and I just think we need a little more time to get into the couples counseling, but we've got a lot accomplished in the last couple months. And, I'm not going to say everything's been going perfect because that's not the real world, but, we're working through things a lot better now than we have ever in the past.
Ms. Totten, any comment?
No, other than we just moved in, that's the only change. So we don't do that whole schedule.
Ms. Hyde, have you been in touch with the parties?
Yes, Your Honor, I have. I spoke with them by phone and they indicated what they've told you today, and also that Macau is continuing in his preschool that we discussed at our last meeting, and that he's doing well there.
So the question, I guess, is if you're now living together and you're co-parenting your son, whether we need any more reviews on this docket. It seems to me we may not. Ms. Height, do you have any input on that question?
Well, Your Honor, there have been a lot of changes through the course of this case. It seems like they have reached a place now where they can cooperatively parent this little guy, and they seem very positive about that. It seems like this could be a good place to leave them, and if something comes up, they can certainly contact the court. But I don't personally have anything that I feel I need to follow up on further.
I would love to check in every month to see how you're doing, but I don't think that's my role here. My role is to essentially get, help people either get a parenting plan or where you've worked it out on your own to say congratulations and let you go live your life. And so it looks like you've reached that point. If you need to come back to court, you can always file a motion and I'll be happy to hear it. But at this point, I'm not going to set a review, and I hope things go well from here on out.
Thank you, Your Honor.
Okay. Thank you, Mr. Garcia, Ms. Totten, and Ms. Hyde, thank you for your work. Heidi Entler and Christopher Entler.
Here.
And is Christopher Entler here? Okay, I don't hear from him. Yeah, Mr. Entler was served on March 3rd. And so that is plenty of time to respond. So, Ms. Entler, you are bringing a motion for adequate cause because you'd like a change in the parenting plan?
Correct.
Just a minute. There's a Christopher in the waiting room. It is Christopher Entler. Let me bring him. All right, we're going to work on the sound with Mr. Entler. I think I'm going to go to the next case, and then I'll come back to Entler and Entler.
All right, thank you.
See Ms. Hart.
Here.
And Curtis Hart, are you here?
I am.
All right. All right. This is a motion brought by, I believe, Ms. Hart to see the children, or I forget how many right now. So Ms. Hart, do you want to start? And then I'll go to Curtis Hart and let him respond, okay?
Okay, thank you, Your Honor. So I prepared what I was going to say here. So I take full responsibility for the mistakes that I made. I was at that time unable to process the grief and the loss for my marriage ending and the trauma that I had suffered from the extreme verbal abuse. The abuse and harassment continued after we separated, as the police records show, to the point that I had a complete mental breakdown. And during that time, my drinking had become unmanageable, and I eventually ended up homeless. I do want to address some of the accusations presented in Curtis and Mandy's declarations, which are blanketed with false accusations. I never abused or neglected my son. He had good school attendance and never missed his doctor or dental appointments. There are no police records, nor had I been involved in any criminal activity or illegal drug use. I've made multiple attempts to contact Eric, but was denied every time, as even declared in their declarations. I have been completely alienated from maintaining a loving, stable, consistent, and nurturing relationship with my son, even knowing, as they declared, that Eric had separation issues and was affecting him mentally. On December 23rd of 2019, I filed and served documentation showing I was in compliance with the parenting plan provisions as instructed by Mandy Hart. And she said that they'd let me see Eric for Christmas Eve. Yet again, I was alienated and not even allowed phone calls, as I was told that was not enough. Your Honor, I respectfully ask the court to deny Curtis's proposed parenting plan. I'm currently on state assistance, as you can see from the fee waiver, and I don't have the means to do supervised visits in the facility. And I don't want to mess up any progress Eric has made over the last 2 years. That is why in my proposed temporary order that we begin with every other weekend. I believe that Curtis's proposed plan is nothing more than vindictive rather than him trying to cooperate with me and do what's best for our son. Curtis is not Eric's full-time physical caretaker. Eric has not been in Curtis's full-time physical care or supervision since 2019, as stated on page 3 of Curtis's Life's Declaration. I've been in stable housing for over a year. I just renewed my 1-year lease last month. I have a 3-year-old daughter, and there's a declaration from her teacher who has been coming into our home once a week for her schooling since we moved in. I've also been in mental health counseling for over a year, twice a week, and I realized that I needed to address my mental health in order to maintain a lifetime of sobriety. Your Honor, I only have my son's best interest at heart. He needs me as mother in his life, and my goal is to have my son live with me rather than his grandparents full time. I'm in treatment, and I have complied with the previous parenting plan provisions, and I've provided all the documentation showing so per court orders in April 2017. As you can see, no other court orders for modification have been signed by a judge other than the original parenting plan in 2017. And I've complied with section 4 of that plan. And I respectfully ask that you grant my temporary order.
Mr. Hart,
Yes, Your Honor.
any response?
Yes. Well, Your Honor, my ex-wife, I was really hoping that she was going to take full responsibility for not being in her son's life for 6 of his 9 years, but it sounds like she's still trying to blame me for leaving the marriage, that she had an affair and moved her boyfriend into the house I moved out. She very quickly just kept on drinking to the point where I had to take her to court to get the papers are there. It's a I'm sorry, I'm a bit flustered right at the moment. I had to take her to court to make her stop drinking in front of Eric, and she had him removed by the courts for several weeks. When she got him back, she destroyed every single thing inside of her house, all the glass. She did that in a blackout rage just the day she got Eric back from not having him for several weeks because of the drinking issues. After that, there was a contempt of order charge that was levied by the courts because of that drinking incident. And that's why she can't see her son. She's never lost custody. I have to also follow the court order that allows her not to see him. And the ball has been in her court this entire time. She's never filed anything as far as I know. I've never been served anything by anybody. There's a lot of what she just said is just false. And what I'm asking for is I believe in Eric's best interest. She doesn't know Eric. She hasn't seen him since he was about 3 years old, or 4, I guess. Anyways, she hasn't seen him in about 6 years. There's a Christopher Antler on the screen now. I'm going to just keep on talking. And so anyway, she hasn't seen him for about 6 years. She doesn't know him. He doesn't know her. Unsupervised visits is just not in his best interest at all. I believe that there's something called reunification that needs to happen. That she doesn't know him. She has made no strides to be in his life whatsoever. She's sent no Christmas cards, no birthday cards, none of that. And my parenting plan is just asking for basically the same thing she is, only supervised visits, so that he can get used to the person that he doesn't know. And I'd also like to not have every single birthday forever, not with my son. I think that that's a bit much to ask for. And I was also just like to point out that the original parenting plan did give her more than what she's asking for now. And all she had to do was go to court and get rid of the contempt charge. But instead she wanted to do all this. So my son lives right next door to me. I see him every single day. She doesn't know how much I'm involved with his life because she hasn't been involved with his life one tiny bit in 6 years. And so I'm just going to be repeating myself basically if I keep on going at this point. So,
all right. Thank you.
There you are. Okay.
Ms. Hart, you get a chance to respond.
Like I said, I do take accountability for the things that I did back in 2017. I did make several attempts to contact him, get him Christmas presents, birthday presents, and was denied, or when they were accepted by his grandmother, they said that they were from somebody else other than me. Curtis was served court documents back in December, December 23rd of 2019, with all my treatment records, clean UAs, everything. And I was 5 months pregnant at the time. I was sober. I had been sober, and it is on court record that those papers were filed, and he was served. It was after that I became homeless. But over this past year, like I had said, I've been in mental health counseling treatment. I've been sober for quite some time now. My 3-year-old daughter, well, she turns 3 tomorrow, she's never seen me intoxicated. So I have changed my life, and I've done all the things that the court required, above and beyond even. So I know that my son is ready to see me, to come home to see me. I heard him on the phone with my mom yesterday saying so, that he wanted to come home and see his mama.
So there was a final parenting plan that was entered on November 22nd, 2017. Issues arose, and in 2018, the court suspended visitation with Ms. Hart, and that order has never been rescinded up until today. Ms. Hart has made some strides in dealing with her issues, and I want to compliment and acknowledge that. She's indicated that she's done an SUD assessment, that she's to do outpatient care. I think she's doing that. She indicates she's been sober for several months. And so now she's come back to court, understandably, to remove the 2018 suspension in order to see her son. I think we need to take a couple steps before we get to that, point. And so, Ms. Hart, I'm going to tell you up front that I've been through this process a number of times where a child has not seen a parent for a while, and we have to reintroduce or introduce the child to the parent and do it in a way that's safe. And it's going to take so long, you're probably going to be very frustrated. But I want you to look at the end of the road where you will have a fairly normal relationship with your son. But we need to take some steps to get there. The first step I'm going to do is appoint a guardian ad litem to do an investigation of Ms. Hart, and also just look at the whole living situation for Eric. So I need to do that first. I'm not going to order any kind of contact between Eric and Ms. Hart for at least a month while the guardian ad litem does an investigation. And that's because I'm not sure what that contact looks like. I don't know if telephone calls are appropriate. I don't know if reunification counseling is appropriate. I need assistance from the guardian ad litem in order to determine that. All right. The order that Ms. Hart provided was an order on adequate cause. And I wanted to address that. I'm not sure that at this point, that's the order we want. Let me just person. There we go.
I'm sorry, Your Honor, I can't hear.
Yeah, I just muted somebody.
Thank you.
We may do an order for adequate cause, which would cause you to go to a trial to change the parenting plan from what it was in 2017. But right now, what I see is I'm addressing whether the contempt order of 2018 should remain in effect. And if not, how does that change? I think that's something I do from this docket. And so I'm going to retain everybody for a while, at least until we get a guardian ad litem report, and maybe take some steps to reunite Ms. Hart with Eric. Okay, I'm going to appoint Heather Call. I'm going to put this over a month, and that's going to be to April 12th. In the meantime, nothing's going to change. That contempt order will remain in effect. Ms. Hart, you're not to have contact with Eric until we do this investigation. Okay.
Okay.
Mr. Hart, any questions?
So do I contact Ms. Collar? Does Catherine?
She should contact you. In the order that I put together appointing her, I provide your contact information.
Okay.
So she will contact you. Good
All right.
question. Ms. Hart, any questions?
No.
Okay. All right. We'll see you back here on the 12th. And
Yeah, I'm here.
we'll go from there. Okay, good. This is a motion brought by Heidi Entler for adequate cause. And so Ms. Entler, if you want to go first, and then Mr. Entler, you have a chance to respond.
So yeah, there's a couple things I want to bring up. Well, so I've been having some issues with my oldest daughter on running away, and he has been aware of that, and he has not made contact with me to like see what we can do or to even let me know she was running away until I got a call at 11:30 at night. Also, I have a child that doesn't want to go over there due to the living situation. There's drug traffic in and out of the house, and his house is infested with roaches. So she doesn't feel comfortable going over there. There's some concerns about my oldest having issues with self-harm, and my daughter did tell me that she had brought it up to him. He was aware of the situation. Well, I asked him, he said no. I found messages on her phone that were from him to her to him, and he didn't show any concern at all. I have my daughter in counseling. She's doubling up on her counselor. She's doubling up on her peers, so she has the support she needs to get through this. And at this point, I feel like it's a safety concern. And that's pretty much all I have. Like,
All right. Thank you. Mr. Entler, any response to the motion for adequate cause?
I didn't even quite hear everything that she just said, so.
Were you able to read her motion and the attached text messages?
The only text messages that she has there on file that she copied off is that my daughter does not feel safe there with her for whatever reason being. I don't know what's going on over there, but my daughter told me that her mom keeps telling her to go kill herself, jump through a window and all that, which I find hard to believe. And I just don't understand what's going on. And her mom's trying to say that I helped her run away when her mom dropped her off at the mall February 19th with all her friends when that thing went down. And then she showed up at my house. Her mom called and asked if she was there. And I said, no, she wasn't, because I was just coming over the bridge to Kelso. Then by the time I got home, her mom called again and asked if she was there. And then I just said no. And then all of a sudden my daughter comes running through the door with her friend. So I said, yeah, she just showed up. And then coming 3:45, I said, how'd you get to Kelso? She goes, my mom dropped me off. And I said, okay, how are you getting back home? She goes, my friend's mom's gonna give me a ride home when we go back over to her house. I said, okay, well, you better get going because it's already 4 o'clock. It's getting late in the day. Well, 2 hours later, her mom calls and says she's coming over with the cops, calling her in a runaway and all this other stuff. And I said, whoa, what's going on? You know? And then I realized my tablet's gone. So I messaged my daughter, said, did you take my damn tablet? Just like that. And she said, no. And then I said, okay. So I gave her a scare and I said, your mom just came here with the cops looking for you, calling you in as a runaway and everything. And all of a sudden, next thing you know, my daughter shows up at my door. Then I called her mom and told her that she just showed up to come and get her. So I don't know what's going on.
What is the current parenting arrangement? Who has the older daughter when? Can you tell me that, Mr. Entler?
Current arrangement?
Is there a parenting arrangement?
Yeah, there was. But Olympia was supposed to call Cowlitz County when COVID started and in that.
All right.
Your Honor, there's a parenting plan here that's established in the Cowlitz County. He has them every other weekend, supposed to have them on Wednesdays. I stopped reaching out on Wednesdays because every time I would, he was too busy or doing something else and wasn't even home for me to drop them off. And he's supposed to have them 3 consecutive weeks through the summer, whether it be together or separate.
All right, let me just tell you the statute, and then I'll tell you why I'm making the decision I am. So whether I find adequate cause is governed by RCW 2609-260. And part of that statute says the court shall not modify a prior custody decree or a parenting plan unless it finds upon the basis of facts that have arisen since the prior decree or plan, or that were unknown to the court at the time of the prior decree or plan, that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child and is necessary to serve the best interests of the child. Ms. Entler, and I guess you go by Ms. Johnston now, brought this motion for adequate cause. She attached to it a number of text messages which showed actually concern by the daughter about being with the mom, Ms. Johnston. And based on that, I think, and I'm going to find there is adequate cause to change the parenting plan. I don't know how it will be changed. You both will have an opportunity to argue that at a trial. That's what happens when I sign an order for adequate cause. Then the parenting arrangement goes to trial again to determine what's in the best interest of the child. So I'm going to sign the order for adequate cause. I'm also going to appoint a guardian ad litem to report to the court as to what would be in the best interest of the children. So I'm going to appoint Amy Turnbull as the guardian ad litem in this case.
Thank you.
All right, so I'm going to sign the order for adequate cause.
Your Honor.
Also, I'm going to set a review on this docket for April 12th.
So are we doing the modification right now for temporary, or is it staying the same as it was?
I'm not making a change in the parenting plan right now, and I'm not changing it on a temporary basis. I need input from the guardian ad litem before I do that.
Okay, thank you.
So it's going to stay the same. And so I know you've submitted a parenting plan, and I'm not going to sign that at this point.
That's fine, thanks.
Okay. Any questions, Mr. Entler?
No, not at the moment.
Okay, we'll see Brittany Chapman and Bryce Chapman.
I'm here.
All right, Mr. Chapman, you filed a declaration saying that the most you can pay would be $250 a month. Have you made any payment at this point?
I have not.
And why not?
Since our last court date, is that what you're talking about?
Well, you haven't made a payment in a long time.
Ever.
You indicated you could pay $250 a month, and it would seem to me you would show good faith by making some payment by today, but it sounds like you haven't.
I can make a payment by the end of the month, that's for sure. A $250 payment.
All right, I'm not sure that's going to be enough, but Ms. Chapman, any response?
Yes, since I did not have time to respond to the declaration, I did actually prepare something to say. So today Bryce was supposed to submit a proposed payment plan written by him and his lawyer regarding the total amount owed. He has not submitted the payment plan. He has submitted a declaration. He has been found in contempt 6 times, does not show up to court, nor even attempt to follow an order. Nor did he submit his income to the court at our for our prior hearing. And at this point, I think the punishment needs to be served. He's delayed the proceedings due to making a claim he was going to be retaining a lawyer when he in fact was not, and also agreed to the court to be submitting that lawyer written payment plan to the court before today, and did not do either of those things. As far as the improper declaration, it does not state facts. It is not a viable payment plan. Instead, it was a way to buy time, badmouth me, and manipulate the system to avoid further punishments. Stating child support garnishes 50% of his paychecks is not accurate because it is also not legal for child support to do so. He also owes the IRS money, so they are taking for that too, as far as I understand. Referring to the clerk's notes, he was supposed to serve jail time, also was supposed to come today with the lawyer presented payment plan. His behavior time and time again shows he believes the rules don't apply to him. I'm ready for this to be done, being dragged out, and the amount he says he owes of $6,500 changes many times throughout the declaration, but the total amount owed is $13,650 from my understanding. I would also like to request to see the receipts from the spousal support payments of $1,000 he claims to have paid to me, because I have never received $1. So maybe those were paid to Brittany Chapman, not Brittany Hancock's, which is now my name.
All right, thank you. Mr. Chapman, any response?
Yes, Your Honor. I do have receipts, and I have receipts that she has signed. And yes, it was with Brittany Chapman on it because that was her name.
Those were maybe child support from 2 years ago.
Mr. Chapman, let's let Mr. Chapman respond.
And I have receipts from money orders that I've paid, that totals in that amount. So I would like to show, and I can show pay stubs of garnishment from child support of 50% of my wages since I started my new job. And I can present those and print those off and turn those in to show. And as far as a lawyer, I had legal aid advice. It was not a lawyer. And this is what we brought up and came to present.
Can I speak, Your Honor?
Go ahead, Ms. Chapman.
I believe that the receipts he is speaking about are right after he moved out of our house, because I totaled up the receipts that I had because I believed that's what he was talking about. And that was when we were just going to be doing child support on our own without the court system. That was child support payments. And that was long before spousal support was even ordered. So I do have those receipts as well. But that is not towards this at all. And as far as child support, they literally can't garnish 50%. But if he says he can submit those, he should have submitted all the other things he was supposed to do.
Mr. Chapman, we've been here several times. Sometimes you were not here, although you were served. We've been here several times on contempt orders for spousal support, and I think a payment for the car. And each time I entered an order to make those payments, nothing happened. I finally indicated that I was going to order 5 days in jail. And then the hearing after that, you did show up, which was the last time we were here. It was on March 1. You were to come up with a payment plan. By that time, you wanted more time to meet with an attorney. No attorney has appeared in this case. You've indicated that 50% of your wages are being garnished for child support. I don't believe that's true because wage garnishments are not that much of your wages, but we'll see. You've indicated you made some support payments. I don't have evidence of that. And honestly, I don't believe it's credible that you can't make a payment more than $250 a month. So I'm going to put this over. And if you've got something to write with, you need to write this down. I need to see wage stubs showing the garnished amount for at least the last 3 months. If you've made spousal support payments at any time, I want to see those receipts. you need to pay Miss Chapman $1,000 by the next time we get together, which will be a week from now. So that's going to be the 22nd of March. If I don't have your wage stub showing the garnishment, if I don't have the spousal support receipts, and if you haven't paid the $1,000, I'm going to order that you report to jail by the next Friday. If you don't report to jail, then I'm going to issue a bench warrant. So those are the things that are going to go on. This has been bounced along over and over without any meaningful response from you, Mr. Chapman, and it's time to have a meaningful response. So that's what I require. We're going to be back here on March 22nd. File all of those documents with the court so I have a chance to review them before the hearing. All right.
Okay.
All right. Thank you. And I think I saw Ms. Croy, do you want to unmute yourself? Good. Thank you.
Jesus, Brad.
So we're here for a review, and I'm just wondering how visitations have been going. I had indicated I wanted Ms. Croy to attend a parenting class, and then I'll check in with Mr. Lawrence also. But Mr. Pena, why don't you go ahead and tell me how things are going from your perspective?
The visits have been going pretty good. She's loving it at my house. I've been doing every visit at my house, like you guys said last court date. And feel like she's getting comfortable over there. She's calling me dad a lot more.
Okay. Ms. Croy, how are things going from your perspective?
Honestly, visitation is going actually pretty well. Francisco has been helping with transportation on Thursdays, which is honestly is a big help due to the fact that I just had a baby 4 weeks ago, so I haven't been able to get a job yet, and so I don't have stable transportation. Haven seems not bothered by it. At first, she would like cry a lot, you know, but now she seems like she's getting used to it, the change.
Okay, good. Thank you. Mr. Lawrence?
I received a report from Beth Fellows yesterday indicating that Fran's visits with his daughter have all gone well. She recommends that he undergo a parenting class from Parents Place that is tailored towards young children. But his visits have been well. He engages with her throughout the visits, and the relationship seems to be coalescing and bonding. His treatment, he has been in compliance on a 1 to 4 scale. In his domestic violence classes, he has gone from a couple of 2s and mostly 3s to now all 3s and a couple of 4s. So he's progressed and is doing well.
Do you think supervised visits are still necessary at this point?
Your Honor, I would recommend that we terminate the supervised visits at this point. Obviously, if anything goes awry, that Kylie or Fran can petition the court and we can revisit the whole issue again.
Was there a name of the parenting class at Parents Place?
Yes, there was, and quite frankly, I don't remember right offhand,
Okay.
but I can provide it to Mr. Pena and Ms. Croy.
Okay. Ms. Croy, how would you feel about terminating the supervised part of the visits?
Honestly, I feel like everything's gone well so far, so I don't see a reason why not to.
Okay. And so that would mean that when Mr. Pena had supervised visits, that time frame would still be a visit, but it would be unsupervised.
Okay.
All right. All right. Well, let me just compliment everybody for moving forward. I think what I hear today is great. I'm going to terminate the supervised portion of the visits. So all of the visits will be unsupervised. The time of the supervised visits should still remain part of the visitation for Mr. Pena.
Can I change Tuesday's visits because I'm missing like 3 hours of work on Tuesday because I gotta leave early on Tuesday for my DV classes.
So what would work better for you?
Any other days instead of Tuesday, Monday, Friday,
Monday
or
work
the
for you?
weekend.
Will
What day?
Monday work, Ms. Croy?
That's what I just asked. I said, would Monday work?
Yeah, we could do Monday.
All right,
Okay.
we can.
All right, you
Thank
can
you.
work. Mr. Pena, I'm gonna order that you attend the parenting class at Parents Place, and Mr. Lawrence will let you know of that class. And I've already ordered Ms. Croy to attend one if she hasn't. Then
Yeah, when do I have to do that by? Because I do have to, like, I have 2 more weeks until I can get a job, and that's when I plan on doing it, because right now I do not have stable income. I mean, I have income, but it's not really realistic for long-term situations.
okay, what I'd like to do is set a review in 2 months, and I would like that completed in the 2-month period. Do you think we can do that?
Yeah, I could do that.
Or at least start it in that 2 months? All right, so let's come back then on May 10th. Mr. Pena, all of the treatment and classes that Mr. Lawrence alluded to, you're still required to follow through on that. Okay.
Okay, Your Honor.
All right. Okay. Again, I'm encouraged by what I've heard from everyone, and we'll see everybody back here, all right, Mr. in 2 months. Okay. Looks like Ms. King, you're in the courthouse here.
Yes.
And we have Ms. Fellows. I'm going to start with Ms. Fellows. At this point, I wonder if you could give me, if you know how things are going between the parties and the visitation.
Yes, Your Honor. I have made contact with both parents since we were in court last. I've actually done random drop-in visits to both homes as well. And I have found no concerns. One of the issues that I had wanted to address or find out some information is about mom's boyfriend. There had been a protection order from his ex-wife a couple of years ago limiting his time with his daughter. So that was a concern. So I wanted to kind of flesh that out a little bit. I did talk to her boyfriend's ex-wife directly to find out, is there still the same concerns? Just find out what's been going on. And she willingly talked to me, said that actually she doesn't have any concerns, that there is no longer the protection order, that Nate sees his daughter whenever is possible given his work schedule. So she doesn't have any concerns about Nate being around children, that type of thing. And I have emailed with Nate as well, and he did basically say the same thing. So at this point, the limitation or restriction of the mother's boyfriend to not be around Andreas, I feel at this point in time should be dropped, to let her and him be a couple around Andreas, see how that goes. So that's basically where I'm at. My understanding from mom is that the intention is that they would be able to basically move in together. So that would be a pretty big change. And I would kind of like to see how that goes. Not that I'm for sure that they would be able to move in together that quickly, but just kind of see how that goes.
All right. Ms. King, remind me again, what's your, how many times do you see Andreas during the week, and how long?
I see him Wednesday through Saturday one week, and the following week, Wednesday through Sunday. It alternates. And I pick him up at 5 p.m. on Wednesday, and he goes home 10 a.m. on the assigned day that he goes home that week.
Mr. Christinger, how would you say things are going at this point?
I'd say things are going all right. I agree with Beth Fellows that obviously we're working towards my son being able to be around her boyfriend. That's what she really wants. That's what she's looking for. I totally understand that. I'm willing to move forward in that direction, of course, also. My only concern is that just from talking with Haley and just kind of like seeing where her life is or whatever and communicating through my girlfriend, I've noticed that she's kind of been moving around a lot. She hasn't really kind of consistently been with her grandma as much. She's been with her auntie, as she said, and maybe at her friends or whatever. I don't know if there's been family issues or whatever. It seems like they've been kind of cleared up now, from what I've heard from grandma. But I just want to make sure that there's stability and consistency if she's looking to move forward with more visitation time or something like that. I want to make sure there's actually consistency, because my concern is that my son's going to be bounced around from different houses and he's not going to be, stable with her. I want her to be able to have her own place stable for him to be at, rather than moving around a lot, because he has been getting sick and me and her are both concerned about his health. So just a little more stability would make me feel more comfortable. But other than that, that's pretty much all I have to say about that.
Ms. King, do you want to address the stability issue that just brought up by Mr. Christinger?
Yeah, I go and stay with my aunt and her 2 children on Friday nights. That's it. It's just so that her children can see Andreas and we get some time together. I don't stay anywhere else when I have Andreas. I am with my grandmother, except for the one night I go to my aunt's. Yes, we visit some of my family and friends, but we don't typically stay the night there. It's usually a couple hours a day. And then when I don't have Andreas, it's usually 1 night a week that I'm away from the house, maybe 2.
If you and your boyfriend move in together, do you have a time frame for that?
We're hoping to move by the end of the summer.
Okay, so that's a little ways away. It sounds to me like things are going well. Ms. Fellows, thank you for the investigation into Nate and alleviating any concerns there. I think what I'd like to do is leave things as they are for a couple more months. And then if we make a change in the parenting arrangement, let's do it 2 months from now. And I just want to make sure things are going on for a while. Okay. And so let me give you the date, and I'm going to ask you both to do something. So we'll be back here on May 10th. And what I would like you both to do is submit to me your proposed permanent parenting plan that you would like to see happen. And maybe what's going on now, it may have a change, but I'd like to see what you both would like. The other option, if you can talk to each other, is if you want to talk about agreeing to a parenting plan, you can do that. That if it's the same or if it's different, I'll invite you to do that. If that's not possible, then submit your own. And on May 10th, I will look at those and we'll talk about it and make some decisions going forward. Mr. Christinger, you raised your hand, I can tell.
Yeah, I just wanted to make sure that did you want the parenting plan submitted in paper or verbally through the next court date?
So if you go to Washington court forms, under dissolution, you can find the form parenting plan, and you can download that and fill it out. Or if you want to, you can type it up on your computer. There's a Word version there. And then, so I do want it in paper form filed with the court. It'll be a proposed parenting plan so that I can look at that.
Okay, so filed with the court, not given to the guardian ad litem then.
You can give it, that might be a good idea to give it to Ms. Fellows to look at.
The copy.
And again, you probably need to file it by about May 1st so that it gets in the court file and I can review it before the 10th. Right.
Okay.
Ms. King, any questions?
No, I don't think I have any questions. I know that I have talked to Miss Fellows. I'm not sure if Megan agreed to the 50 schedule, but I did bring that up to her and I've talked about that as well. I believe I talked about it.
Okay.
Yeah, I did. Sorry, I did hear about the 50-50 proposition, and I mentioned to Beth that our current schedule that we have now is pretty much 50-50 as is. And if she's willing, I wouldn't mind keeping what we have now, just adding Nate, incorporating her boyfriend to the whole scheduling, because that's what I know is the main concern. So the scheduling that we have right now is actually really intact and solid for me. I don't know how it is for her, but it actually is working pretty well for me. But it's pretty much 50-50, I would say, as it is right now. Maybe there's like a couple hour difference, but.
So that we're going to keep that for the next 2 months. And if either of you, what I'm opening this up to is if either of you want to make a change, we'll consider that in May. Also, if you want to think about how you'd like a summer schedule to work, how you'd like different holidays to work, you can put all that into the parenting plan. Okay.
No, that sounds good. Thank you, Your Honor.
Okay, we'll see everybody back here then on May 10th. Thank you.
Hello, Your Honor.
Good morning.
Good morning, Your Honor.
Looks like I had ordered telephone or video visits twice a week. How have those been going, Mr. Blacklaw?
They've been doing pretty well as far as I know.
Okay. Ms. Myers?
Well, I have a whole nother opinion on that.
You're coming through really light, so I'm going to ask you to speak up a little bit.
Can you hear me better?
Better, yes.
Perfect. Okay, so I have another opinion on that.
Okay.
Normally, these visitations are supposed to last normally an hour or so. They last maybe 6 minutes. Sometimes a range to 25 is as long as they'll go. My daughter's span of paying attention, I guess, is like in a fragments of times when she gets super tired. So I'm not sure if they're purposely doing this to where she only wants to talk to me for a short amount of time and then rip the phone away, or what's going on, because I'm pretty sure we agreed it was supposed to be every Tuesday and every Friday, but I have only talked to my daughter over video chat 4 times. Well, sorry, 3. This last time, that was my bad. I wasn't home. But I did call her. So, I'm not really sure if he's making excuses for the times that he wants to go to his mother's to drop her off. But it's seeming like he's just not taking the initiative to do it on time. There were numerous amount of times where it was because the snow or this, which is understandable, but when I can drive through woodland, in a little car perfectly fine. It's fine. I'm pretty sure he can drive in little bitty snow because I've seen him drive in worse. So that was an excuse. Secondly, when I do talk to my daughter, she is normally present, which is his mother, which is understandable because of the situation, but constantly trying to take the phone from my daughter because she can't hear me or see me or this and that, and constantly trying to fix the phone is a massive problem. So obviously this video chatting isn't working. So is there any other way we can do in-person visitations? Because if the phone call, the video chatting isn't working, what can we do?
Okay, thank you. Let me hear from Ms. Turnbull. Have you had a chance to speak to the parties?
I have. Mr. Blacklaw has returned his paperwork. I have had an interview with him. I've had a Zoom, visit in his home. I've seen Hazel. I've interviewed some of his collaterals. Ms. Myers has not returned her paperwork. She has had over a month to do so. She's been in communication that she's trying to. I've given her very direct information about how to do so. She has not done so. So that is where things stand with Ms. Myers. I have spoken with a number of collaterals and CPS, and I have some very serious concerns about how the child abuse that occurred to Hazel while she was in the care of Ms. Myers. It was extreme and very concerning.
Mind you, Your Honor, these are accusations and there has not been anything filed. And as the person standing right there is going to find out, that those rumors are going to be squashed when they find out that the Sunday I picked her up that she had red marks all over her body. So let's continue, Austin. We'll figure out who happened there. I have proof on that one. I took pictures the day I got her. So we'll continue that in court.
All right, Ms. Myers, I'm not going to consider in-person visits until you provide the information necessary to the GAL and I get additional reports from the guardian ad litem. So it really is in your best interest to cooperate with her, because I'm not going to consider
times to send that paperwork through. I have contacted the UPS people that she has told me to go to, which I did that. And when I went over there, they told me that they could not find her IP address. So I don't know what else to do. I have tried asking her for a physical address that I can go to. I don't care what the distance is. I have asked. I have tried doing a picture of the actual paperwork.
Do you have Ms. Turnbull's phone number?
I do have her phone number.
And you've been in touch with her, I think. Make sure you, well, you need to get her the what she calls a packet, which is information that you need to fill out to get to her. Okay. All right. The order, the restraining order I'm looking at says that there will be 2 telephone visits a week. There's no indication as to how long they will last. We're dealing with a very young child at this point. I understand it's not optimal, but the court's interest is to make sure that the child is safe. And the best way to do that at this point is to keep the telephone visits. Mr. Blacklaw, try to facilitate those the best you can. But if the child gets distracted and doesn't want to talk after 10 minutes, I don't know that anybody can change that, because
She's a year and a half.
What I've got is 18 months, I guess 18 months old now. So I understand that's difficult, but I can't order, I'm not going to order in-person visits until I get more information from Ms. Turnbull. Okay. Let's come back in a month and see where we're at then. So that will be April 12th.
Is there any way we can get it a later time? Because I'm
Then
going to
9
start
o'clock.
working here soon, and I'm not sure if
These are only heard at 9 o'clock, and I don't know when I'm going to call your case. So I can only set it at 9. There's one other docket on Thursday that's also at 9, but right now, for everybody's purposes, at least at the court, we need to keep it on Wednesday at 9.
Okay.
All right, so we'll see you back here on April 12th at 9 o'clock, and the telephone visits remain in place. Okay.
Okay.
Thank you, Your Honor.
Yep, I'm here.
All right. Thank you. And I did see Mr. Utter. All right. We're here for 2 things, I believe. One is to discuss child support, and the other is for a report from Mr. Lawrence. I think what I want to do is hear from Mr. Lawrence first, and then we can discuss child support issues after that. So, Mr. Lawrence?
Yes, Your Honor. I've had a chance to make contact with both parties. I was out last week and met with Kirby and Parker, and Ms. Young has provided me with a copy of her paperwork, and so that's going along well. Mr. Utter, we have spoken via email and telephone. He has paid me for half of the fee so far. We had an appointment scheduled for earlier this week, but a conflict arose, and so we rescheduled for later today. I'm going to be going out to his home this afternoon, and we have made arrangements on the continued payment to make a full payment before my final report is done. So Mr. Utter was provided with copies of my paperwork. I believe he's going to have that for me this afternoon when I go out there. So at this point, things are going well.
Okay, good. And let me thank both parties for cooperating with Mr. Lawrence. Let me start with Mr. Utter. Who is Parker 10 or is he older than that now?
No, he's 10.
He's 10. Okay. What is the current visitation schedule that?
There is none, Your Honor.
You do not see Parker, is that right?
No, I was seeing him until recently.
Okay.
Since about Christmas.
What happened recently?
I don't know, Your Honor. We couldn't come to agreements with the parenting plan together, so I petitioned the courts to ask for the court's help in doing so and facilitating a relationship with him and visitations.
We thought he was just going to come over to your house occasionally with other children at your house. That hasn't been happening.
Yeah, I don't know if it's coincidentally or what, but all of a sudden he's not around the neighborhood much or around the 6 friends that he's normally around in the neighborhood.
Okay.
And it's ironic or what, Your Honor, I don't know. Ever since this happened, hasn't been around.
Okay. Well, Mr. Utter, I'm not going to make a formal change at this point. I need more information from Mr. Lawrence.
Okay.
And it looks like we're moving in that direction. Just in terms of a review hearing, Mr. Lawrence, how far out do you think that should be?
Let's give it 30 days, Your Honor. I should know a little more by then.
That would be 4 weeks from now would be April 12th. Will that work, or do you think it should be a week later?
I would hope that I would have at least an oral report for the court by the 12th.
Okay, so we'll take care of that. Let's go on to the issue of child support. And I think Ms. Llewellyn is, why don't we start with her? Are you with us, Ms. Llewellyn?
Yes, I'm here.
Have you done yourself any calculation or what, do you have an amount in mind that you'd like to see for child support?
I don't know. I don't know what the court would recommend. He has been an absent father since before Parker was born. He has gave me $150 in 10 years. So, and he's never helped with back to school, birthdays, Christmases, medical, nothing of that sort.
Okay.
And there's been no formal parenting plan, nor was Parker going over there at a regular.
Right.
Parker went over to hang with his friends. So I'm not sure how. Anyway.
Okay. Mr. Utter, what's your position on child support? I know you filed some financial documents.
Yes, Your Honor. So we at one time had agreed on $150 a week between the two of us. I'm out of work and was at the time. That's when I came up with when I paid the initial $150 that she had agreed upon. At that time is when I said, okay, now I'm paying child support. I'd like more consistent visitation with Parker and something in writing, something notarized. And that's when I stopped hearing from her and Parker from coming over. As far as not being in his life the last 10 years, it was requested by her and her husband that I not come around because of my wife at the time, which we discussed last time. I don't know if you remember or not. It was never by choice. At one time he was on my insurance when he was first born. Like I said before, I was doing what I thought was best for his safety and what she thought was best for Parker as well for his safety. I've offered recently to put him on my medical insurance as well, at which she's refused or not given me the social security numbers or anything to put him on there. It's not for lack of me wanting to do any of this. I petitioned the courts to have a relationship with Parker, to pay the child support. It was her who brought Parker back into my life and her who decided when she was ready to allow Parker to know who his real father was. It was not my decision. If it was my decision, it would have been years ago. I would have been part of his life. Like I said before, prior, I'd gone over to their house and try to give him gifts and stuff like this. This year alone, this school year, I tried to get him school clothes and take him shopping. He was uncomfortable with. Kirby had said, well, his older brother Brody can go with, at which times it didn't work out. We have text message after text message saying all this stuff. We did have a relationship with Parker. There's pictures all over my wall with him coming over, having dinners, playing sports, riding bikes, stuff like this over the last year.
Wow.
Not just friends. He's been over by himself. She's dropped him off by himself, where he just walks right into my door without knocking, and he's chummy with my kids, his brothers, his sisters. And that's where we're at, Your Honor.
Okay. Still on disability?
I am. I'm not back
And
to work.
you get $12.75 a week from disability?
Correct.
Well, I think we're moving in a direction where we're going to figure out how to reunite you and Parker.
Very well.
And one of the steps in doing that is to begin to be responsible for child support for Parker. That's going to improve Parker's life. It's going to create a connection, I think, between you, Mr. Utter, and Parker, even though you're not able to see him right now.
Sure.
And so it sounds like there was a proposal of paying $150 a week from your $12.75. On a temporary basis, I'm going to order that. So you should pay Ms. Young $150 child support each week.
Okay.
When you get that check or shortly after. That may not be the final amount. The final amount will probably depend on what you earn when you're out of disability, and we can look at a more normal income.
Right.
But for right now, I think we need to start that. And then we'll be back here in a month. Mr. Lawrence thinks he can have a verbal report at a minimum, which will help me make a decision on how we're going to reintroduce Parker to you, Mr. Utter, and create some time together. Okay.
Your Honor, he also was just with my mom a week or so ago, and my kids currently, they went out, they had McDonald's milkshakes. I mean, I know we have to reintroduce and everything else, but he is comfortable with my family. He is comfortable with his siblings. I know there's a process here, and I understand that. And that's why I asked the courts to help me out with this. And I'm not opposed to anything the courts or Your Honor says. I know.
And one thing I would like to say is Parker's always had a.
Miss Young, just,
Sorry.
I don't think Mr. Utter finished, and I do
Oh,
want to,
okay.
but let's let Mr. Utter finish.
Okay.
I'm sorry, Your Honor, that made me lose my train of thought. I just wanted the courts to be aware that, you know, he is with my family and his siblings, and he is comfortable with that, just so the courts are aware.
Okay. Miss Young, go ahead.
One thing that I was brought to my attention by his mother was that Parker's older brother was arrested, and which then it got brought up because one of Parker's friends at school were like, "Hey, Parker, did you know your brother got arrested on Friday?" That's really, I don't know, it's kind of embarrassing for Parker. And I told Parker, because Parker does like his brother Corbin. So anyway, Stephen's mother did talk to us about it and reassured us that his older brother was going to get counseling and stuff. And Parker has always had a relationship with his stepmom, Teresa, since the time she was there when Parker was born. And we've always tried to maintain that.
That's false, Your Honor. I'll have my mother testify to that. Not the whole 10 years.
Okay, I'm not gonna
I understand.
delve into whether the older brother was arrested and why.
Thank you.
My interest here is what's the relationship between Parker and Mr. Utter.
Yeah.
And so
thank you, Your Honor.
Let's come back here then on April 12th, and we'll move forward. And I'm going to enter what's called a bench order relating to the child support payments. Okay.
Okay.
Okay. Thank you both.
Thank you.
Your Honor.
Yes.
To whom do I have to pay child support? And does it have to be weekly, monthly, now? I mean, when do I have to wait till next hearing to get those details?
That should start right away.
Should I get with Keith on that, or?
When's your next check? Do you get the check weekly?
I do, Your Honor.
So I don't know when that check arrives, but when the next check comes in,
It should be.
after that, you should pay $150 to Ms. Young.
Okay, directly to her.
Directly to her, yes.
With receipts saying I've done that, so there's no.
Absolutely.
Okay.
If you want to do a money order or a cashier's check, that would cost
Venmo or PayPal, some app like this is acceptable.
If that works out, that would also create a receipt for you or
absolutely
an email response. I certainly would not walk over with cash and give it to her without any kind of evidence of that. I would do something that would keep a record of it. Okay.
Okay, very well. Thank you, Your Honor.
Mr. Derby, I think this is your motion for adequate cause.
Yes, Your Honor.
Do you want to address that briefly?
Well, he's been running away after he filed the CPS report. The last month he's been with me permanently. His mother has tried to come and get him, but he's just so deathly afraid to go with her that he's refused to go with her. He just seems really scared. I don't know what exactly is happening at his mother's home, but he's really adamant about not going there. So like this week, he was supposed to be with her, but he refused Friday. So he's been with me still. It just seemed like things got a little bit worse for him at her home after the CPS report was filed.
Ms. Hyatt, have you looked into this matter at all?
Your Honor, this is an old case. I was appointed, I believe, back in December,
Right.
and I did have contact with Destin at his school. It's been many months ago, so I don't. At that time, it was decided that there was not adequate cause, and so I set the whole matter aside. So I kind of dipped into it and then stepped back. I have no new information for the court today. I don't know how you want me to proceed.
Okay. Well, first of all, if I find adequate cause today, do I need to reappoint you, or do you think that the old appointment is sufficient?
Let me look at my orders appointing. I guess one change would need to be made. I was supposed to have a report filed by January 4th of 2023. So obviously I missed that.
All right. Well, all right. Well, let me make a decision on the adequate cause first.
Okay.
Earlier, I read the requirement for adequate cause. Again, that's at RCW 2609260. And it's the court shall not modify a prior custody degree or parenting plan unless, and I'm skipping some of it, it finds that a substantial change has occurred in the circumstances of the child or the non-moving party, and that the modification is in the best interest of the child. And from what Mr. Derby has presented in his motion, I believe he meets that standard. So I am going to sign your order for adequate cause.
Thank you, Your Honor.
I'm going to do an amended appointment of Ms. Haidt as the guardian ad litem. And she will need to do an investigation that will assist the court in making a decision down the road. What will happen eventually, Mr. Derby, is this will be put on the trial setting calendar and set for a trial on the issue of the parenting plan. Ms. Haidt needs enough time to do a report before that. And so I'm going to keep this case on my docket for the time being so that I can at least track that report. I'm going to set a review hearing for April 12th at 9:00. That will be simply for the purpose of determining if Ms. Haidt has met with the parties and whether she's got all of the documents she needs. I'm not expecting a report at that time. But I do want to make sure things are going forward. When it's clear that Ms. Hyde has completed her investigation, then Mr. Derby, I'll direct you to put this on the trial setting docket so you can set it for trial. Okay?
Okay, thank you, Your Honor.
All right,
in the meantime, Your Honor,
yes.
I'm just concerned. I'm concerned about my son and how he's absolutely just dead set on not going back to his mother's home. I was just curious if I know that the police have been called. He's ran away. He was even put on the runaway list. I just hope that we could keep him at home until this is found. It's hard to send him somewhere when he acts so scared.
What
It's fine. Okay, you got to be quiet.
I just let a couple people in. Is either of those Melanie Vianola? Doesn't appear to be. So I don't know that today I can change the parenting plan. Here's what I would suggest you consider is if you think the mother is a threat of harm to your son, maybe you should bring a motion for a restraining order, and I can consider that and perhaps put some restrictions in place.
Okay, Your Honor.
All right, but right now, based on what's in front of me, what I'm able to do is say, yeah, there probably is enough evidence here that we need to revisit the parenting plan, but I don't know that I can change the old one at this point. Okay.
Okay, Your Honor.
Okay.
Your Honor, if I might just ask one quick question.
Sure.
If on April 12th, you're really looking for just a compliance review that the parties are engaged, and then do you have an idea that you would also like a report from me at a future date? And if so, do you have a timeline in mind for that?
Maybe you could help me with that. I would hope we'd have some type of report by, say, May,
Okay.
either mid-May or late May.
Okay.
Okay.
I may have some other verbal information for you on the 12th if I'm able to visit with the parties before then as well. But I'll for sure attempt to have a written report then on the date that you set for May.
Okay.
Thank you, Your Honor. I appreciate that guidance.
All right. Thank you.
Is that all, Your Honor? I'm sorry. I didn't mean to interrupt.
I'm sorry, Mr. Derby. Yes, that's all. You're free to go.
Oh, okay. Thank you.
Yes,
Let
can you
me
hear me,
check a
Your Honor?
message here. Yes, you're actually on a bit of a different docket than this one. So I need you to go out of this docket and then sign in on the 1030. It's called the state's paternity trials.
Okay. All right. Thank
So
you, Your
sign
Honor.
into that. I'm about to end this docket. I'm going to open that one up. So if you just go in and out, you'll be there on time, and I'll.
Okay.
Okay.
Will do. See you in a minute.
Mr. Hunter Irvin was present at his last review. It was an early review on March 1st to determine if he'd made his $800 payment. He had not made that payment as of the date of the hearing, but it did post the following day on March 2nd. So that $800 payment did post for that partial of his $1,750 purge, as the court had ordered. The court did order he pay for the month of March $1,000. He does not have that payment posted yet, but he does have, as Your Honor indicated, until the 25th of this month to make that payment. What the state would be requesting at this time is that Your Honor had indicated that you would be likely to have a $1,250 payment as a minimum requirement for April. So requesting that that be ordered, as well as a job search work log, because even though he has made those partial payments, he has not made payments in full. So we are still requesting that that requirement of his order be fulfilled so that we have an indication as to how much he is working currently.
Mr. Angelico.
Thank you, Your Honor. We can inquire, but I believe that Mr. Irvin no longer is, because it was a project, but he was doing construction. Mr. Irvin, are you currently doing construction work or working for the person that you were working for?
No, I'm just, I'm doing home inspections.
Okay, so you have the additional income source from that project is ended?
That's correct.
Okay, So it was not an ongoing construction project.
That's correct.
Okay. So I believe, Your Honor, that, it's in regard to the payment for this coming month, we would ask that be taken into consideration and that he would, in addition, do a work log.
All right, I think the purge amount from Alaska is $1,750 a month. And
The purge amount is set fully at 1,750, Your Honor. We've just been requesting those lower payments. We have not requested a change in his overall purge amount at this time.
Well, I think the state's position all along is he needs to pay the $1,750, and I've been giving some consideration to allow the business to ramp up in the spring. And so March is at $1,000. I'm still going to order $1,250 for April because that is still well below what the Alaska court has ordered. So I'm going to order a payment in April of $1,250. And then also we need to see a job search and work log, which will show the different assignments and jobs that Mr. Irvin has been able to do between now and the next hearing. And the next hearing then will be April 19th. Is that right?
That's correct, Your Honor.